to the Leader of the Opposition at this stage, just to keep a bit of balance.
Thank you, Mr Deputy President. I lead for the Labor Opposition on the National Redress Scheme for Institutional Child Sexual Abuse, Commonwealth Powers Bill 2018. The Opposition does not oppose the bill. The object of the bill is to refer various matters to the Commonwealth Parliament to enable that Parliament to legislate on matters concerning them. Specifically, that will allow the Commonwealth Parliament to legislate for the National Redress Scheme for Institutional Child Sexual Abuse. The Commonwealth Constitution would not permit the Commonwealth Parliament, to legislate validly for these matters without a referral by the State Parliament under placitum 37 of Section 51 of the Australian Constitution. The bill refers two things in particular. First, it refers a text reference annexed as Schedule 1 to the bill, the National Redress Scheme for Institutional Child Sexual Abuse Bill 2018, which is proposed to be the Commonwealth Act. The second item is an amendment reference that provides for the enactment of amendments to the scheme. The bill is a response to recommendations made by the Royal Commission into institutional responses to child sexual abuse. Whilst the scheme and the Commonwealth Bill are broadly consistent with the Royal Commission recommendations, there are, however, significant differences, some of which were canvassed briefly in this place yesterday. This is the first referral bill to be introduced into a state or territory legislature and of this kind, and the scheme is proposed according to public announcements to commence by 1 July. To date, Victoria has agreed to participate, followed by the ACT, the Northern Territory and Queensland, according to public reports at least. Without referral bills such as this, the scheme will not be able to operate. The scheme is proposed to operate for 10 years. The constitution of the National Redress Scheme is set out in the Commonwealth Bill annexed to Schedule 1. A convenient summary of the scheme is set out in Clause 4 of the Commonwealth Bill. Redress is provided for abuse that occurred when a person was a child and consists of these components: a redress payment of up to $150,000, a counselling and psychological component, and a direct personal response from the institution. For an entitlement to redress, a person had to be sexually abused. The abuse must be within the scheme, and a participating institution must be responsible for that abuse. At the time of application, the applicant must be an Australian citizen or permanent resident. The responsibility of an institution is based upon whether the institution is primarily or equally responsible for the abuser having contact with the applicant. If the scheme operator considers there is a reasonable likelihood that the person is eligible for redress, the operator must approve the application and make a redress offer to that person. That offer may be accepted or declined. If the offer is accepted, then the person must release the institution and officials from liability, although the abuser is not released from liability. Participating institutions that the operator determines responsible for the abuse are liable for the costs of providing redress. They are also liable to contribute to the costs of the scheme. The bill mandates that redress under the scheme should be survivor-focused. The scheme's operator is the Secretary of the Commonwealth Department. The operator must be satisfied there is a reasonable likelihood that the person is entitled to redress. This, of course, is not the traditional burden of proof in civil proceedings. Clause 15 of the Commonwealth Bill sets out relevant circumstances for determining responsibility of institutions. The operator must make a determination on an application as soon as practicable. A person can only make one application for redress under the scheme. A person cannot make an application while they are in jail, although this can be waived in exceptional circumstances. Clause 63 provides that a person is not entitled to redress if they have been sentenced to a period of imprisonment of 5 years or more, unless the operator is satisfied that providing redress will not bring the scheme into disrepute or adversely affect public confidence or support for the scheme. This seems extraordinarily uncertain in its effect, and therefore, given particularly the nature of the subject matter with which we're grappling, wrong in principle. It seems as though redress is available only when the nebulous concept of public opinion, as mediated by a public servant, is interpreted in a particular way. Likewise, a person is not entitled to redress while a security notice is in force. In his second reading speech in the other place, the Attorney-General did touch on some of the controversial aspects of the national scheme, including the one I just mentioned. Certainly the establishment of a national scheme is to be welcomed. It is common ground amongst almost everyone who has turned their mind to these issues that the existing Commonwealth system has not served all survivors well. And the example of Mr Ellis, of course, was noted by the Honourable Natalie Wood, is a particularly powerful example. The establishment of a comparatively simple scheme, certainly simpler than common law proceedings, is to be welcomed, especially in a non-confrontational structure. That was the recommendation of the Royal Commission. There are, however, unwarranted and unexplained divergences from the Royal Commission recommendations in the scheme in this legislation. The most obvious relates to the quantum of redress payments. The Royal Commission Redress and Civil Litigation Report recommended monetary payments to provide tangible recognition of the seriousness of the hurt and the injury suffered by a survivor. Recommendation 19 of that report provided that the maximum payment be of $200,000. This was one of the figures canvassed in the consultation papers of the Commission. The Royal Commission noted that the amount and the other amounts in their papers did not exceed common law damages for non-economic loss, referenced at page 247 of the report. There were differing views in response to the consultations. The Truth, Justice and Healing Council, for example, had argued for a maximum payment of $150,000. The Uniting Church, on the other hand, supported the maximum payment of $200,000. At page 252, the Royal Commission concluded, and I quote, "We are satisfied that the appropriate level of monetary payments under redress is a maximum payment of $200,000 and an average payment of $65,000. We consider that the higher maximum payment is appropriate to allow recognition of the most severe cases, taking account of both the severity of the abuse and the severity of the impact of the abuse." The conclusion and recommendation was reached after considerable thought and consideration by the Royal Commission and after significant consultation. In the view of the Labor opposition, there is a substantial onus on those who reached a different conclusion. Those advocating for this bill, in its present terms, have not, we think, discharged that onus. And I remind honourable members of the reference of the previous speaker, the Honourable Natalie Ward, to the difference between legal outcomes and moral outcomes. And I think this is one of those aspects that could well have been done better. Also departing from the Royal Commission recommendation, there is no minimum payment set in the bill. I draw the attention of the House to comments from the Australian Lawyers Alliance on the issue of quantum. The ALA said, and I quote, "The ALA believes that maximum amounts in line with those recommended by the Royal Commission, indexed for CPI over the lifetime of the scheme, are appropriate. As the Royal Commission noted, a maximum amount of $200,000 is appropriate to allow recognition of the most severe cases, taking account both of the severity of the abuse and the severity of the impact of the abuse." Unquote. The ALA also said, and I quote further, "It is important that the amount of redress paid adequately reflects the seriousness of the survivor's experience and the impact of the abuse on their lives. Particularly in the most serious cases, some survivors might not feel that what they are offered adequately reflects the impact of the abuse on their lives if the maximum redress payment is restricted to $150,000, unquote. The ALA also argued, and I quote again, "While the scheme is not intended to offer the level of payment that might be available through civil litigation, applicants will compare what is available through each route. While many will be happy to accept a lower payment to avoid the stress of litigation, the greater the gap between the two potential amounts, the less attractive the scheme will be to survivors. If maximum redress payments are so significantly below what might be achievable through civil litigation, some survivors might feel forced to pursue civil litigation even though they would prefer not to. In turn, this will mean that fewer institutions will benefit from the scheme, from the still dramatically lower redress payments available under the scheme, as well as accruing significant legal fees that will arise should survivors choose to pursue litigation." Unquote. The basis for the lower maximum figure of $150,000 seems, as best we can determine, to be maintaining, or protecting rather, the financial position of various institutions. This, in my view, is an entirely wrong and perverse way of looking at the issue. Redress payments are to recognise the seriousness of the pain inflicted and the seriousness of the consequences of that pain. They are not to limit the degree of pain felt by institutions providing the redress. That is an entirely wrong way of looking at it. The maximum should not be $150,000 but the $200,000 as recommended by the Royal Commission. The problem, of course, is even more acute when it is remembered that a significant number of institutions involved are or were government-owned and run. By limiting the maximum payment to $150,000 rather than $200,000, governments are limiting how much they will have to pay. They are clearly judges in their own cause on this point. It is to the government's benefit to limit these payments. There is also an element of unfairness as well. If a redress payment is accepted, the survivor ends their common law rights. If successful in a common law action, a victim may well recover vastly more than $200,000. If, as the Royal Commission suggests, this amount of $200,000 is below the non-economic common law damages, then obviously a successful common law claim will result in much more than this amount. Indeed, the available evidence of cases on this point supports that argument. Again, this seems not just wrong in principle, but could have counterproductive consequences in practicality. That is, if the maximum payment is too low, it may well encourage survivors to pursue common law claims. New South Wales Labor welcomes the national scheme, but unequivocally feels that the Royal Commission recommendation of a higher maximum amount should have been adopted. I note that on this we are in agreement with the position of the Federal Parliamentary Labor Party. In my view, the scheme on that point shortchanges survivors. There are other differences between the scheme and the Royal Commission recommendations as well. Page 347 of the Royal Commission report says, and I quote, "We see no need for any citizenship, residency or other requirements, whether at the time of the abuse or at the time of application for redress," unquote. That is not what is contained in the draft bill annexed to Schedule 1 to the bill before the House. So far we have heard, I think, no credible argument in support of this variation. This also raises particularly asylum seekers, refugees and stateless persons who have suffered abuse in immigration centres. Particular issues for jurisdictions other than the New South Wales Parliament, but I know, well, we have a disquiet at these provisions and their implications, because it seems to be saying if you're not a permanent resident or citizen at the time you make the application, somehow the abuse that you suffered didn't exist or isn't worth anything or isn't worth even being recognised, and that really cannot be the case. The bill also has a restriction on claimants based upon imprisonment or conviction of a crime. These proposals were not contained within the Royal Commission report. Early media reports suggested individuals convicted of sex offences and anyone convicted of crimes for which there was a maximum sentence of 5 years or more in prison would be automatically barred from redress payments, and that is not what happens in the scheme, as I indicated earlier. There is a discretionary element in the bill that makes it less onerous, but it seems to me to increase dramatically the uncertainty surrounding this aspect of the scheme. The ALA's submission on the original report said, and I quote, "For many, the sexual abuse they suffered as children will have contributed to the life of crime they later embarked on, or the single criminal offence, which could be relatively minor, with no sentence imposed if the maximum possible was 5 years. In relation to drug crimes, for example, the Royal Commission heard time and again evidence from survivors who explained that they were driven to drug and alcohol misuse as a means of blocking out memories of the abuse that they suffered. A blanket ban on sex offenders will also capture some people who have engaged in low-level offending," unquote. The nonsensical outcome, of course, is that people in these categories will be forced to litigate at common law, potentially obtaining significantly greater monetary recompense than they would have under the redress scheme. And while touching on perverse and perhaps unintended outcomes, I also draw the contrast between the National Redress Scheme endorsed in this bill and what is left of the state's victims' compensation arrangements after its evisceration several years ago by the coalition government. The maximum lump sum payment under the state-based system is dramatically less than is provided for in this bill. The result of the coalition government's changes a number of years ago, I think it was 2011 or 2012, is that the amount of money survivors received in this roulette system is determined not by the type of injury sustained or its impact on the survivor, but rather whether or not an institution was involved. As I've said, the Labor opposition thinks that the bill before the House should provide a higher maximum monetary payment under the National Redress Scheme, but the figures in the bill demonstrate just how hopelessly inadequate the current New South Wales Victims Compensation System is. Mr Deputy President, with those observations and qualifications, the New South Wales Labor opposition does not oppose the legislation.
Just before you concede the floor, just Reverend Nile, just one moment. It's likely during the debate that Mr David Shoebridge, and whilst he's not here, I anticipate that he'll be here, will be making a contribution and will be indicating some amendments that he will be moving that will require the House to go into Committee of the Whole. Good, you're here. What I invite members, before we go into the Committee of the Whole, to do is to consider this paragraph, and no doubt the clerks can assist by reference to some material in terms of Senate practice, but nevertheless, in a practical guide to Committee of the Whole, page 6, paragraph 2.23, the following observation is made. On occasion, the House is required to consider a bill to give effect to an agreement between state and Commonwealth and state governments. While the Council does not concede any limitation to its power to amend intergovernmental legislation, questions have arisen as to the power of state legislatures to amend the terms of the agreement, in brackets usually attached as a schedule to the bill. I put in paragraphs here, as done in this case, close brackets, due to the inherent risk that an amendment may result in the legislation in one state being inconsistent with the legislation passed in other jurisdictions. It is clear that members may vote against the clause or schedule to reject the agreement. However, if a member intends to propose an amendment to the terms of an intergovernmental agreement,